Good afternoon. I'm Jason Adkins, Executive Director of the Minnesota Catholic Conference, the public policy voice of the Catholic Church in Minnesota today. And I'm here with a number of faith and education leaders to talk about the importance of putting religion back in as a protected class in the proposed Equal Rights Amendment. We are here today because enabling discrimination based on religion is wrong. It is very troubling that legislators are considering depriving Minnesotans of an important legal remedy to combat anti-religious bias by failing to include religion in the list of identities and classes protected by the proposed Equal Rights Amendment. The practical effect of this omission is that it communicates as a matter of our fundamental law that protecting people from religious discrimination, whether they practice a religion or not, is not a compelling governmental interest, and that claims of anti-religious bias or discrimination by state actors will receive less judicial scrutiny than claims based on other classes or identities. There is a long history of discrimination against religion by state actors. Just to name a few, consider in the Missouri Governor Lilburn Boggs' Executive Order number 38 that ordered the expulsion of Mormons from Missouri. General Ulysses S. Grant 1862 Order number 11 removing all Jews from Kentucky, Tennessee, and Mississippi. The 1922 Oregon ballot initiative promoted by the Ku Klux Klan and the Freemasons that sought to all but abolish Catholic schools in Oregon. The 1940 prosecution of Walter Gabaitis after his son and daughter, consistent with their Jehovah's Witness faith, declined to pledge allegiance to the flag. And of course, who could forget the 2017 travel ban executive order, characterized by many as the Muslim travel ban issued by President Donald Trump. President Grant's decision to promote anti-Catholic Blaine amendments, including the one that was eventually adopted here in Minnesota, are now likely unconstitutional as a matter of federal, U.S. and U.S. Supreme Court decisions. But religious discrimination by state actors is not unusual or particularly rare throughout our history. Now, almost 80% of Minnesotans identify as religious, and Minnesota has a very diverse religious population, with some of our counties being among the most religiously diverse in the nation. According to a recent Gallup poll, almost half of all Americans claim that religion is very important to them. That is, it is a core part of their identity. These facts underscore the importance of including religion. That is because it provides protection for all Minnesotans, including the religiously unaffiliated, and because anti-religious bias of one type or another is an unfortunate reality, whether between religious and ethnic groups, or by state actors who are ignorant of the law related to religious exercise and religious establishment, or by those who profess a rigid secularism. For example, according to the FBI, anti-religious hate crimes increased 30% between 2021 and 2022. Religious-motivated incidents make up 17.3% of hate crimes. Interestingly, Pew Research indicates that there is not one religious group in the United States for whom a majority of Americans has a somewhat or very positive opinion, with Jewish Americans having the highest favorable rating at 35%. By contrast, between 20 and 25% of those polled have somewhat or very unfavorable views of Latter-day Saints, Muslims, atheists, and evangelical Christians. Religion should be included in the ERA as it is in most civil rights ordinances. Doing so is consistent with both good policy, and core American values. In fact, 87% of voters agree that tolerance of others' beliefs and the freedom for Americans to live according to their values are core to being American. Another 82% of voters agree that First Amendment rights of free speech and religion are critical to the well-being of the nation. Including protections for discrimination based on a person's religion ensure that each of our own biases and prejudices do not compromise the well-being of others whose beliefs and practices are different than our own. This is especially important in the context of the policies and practices of state actors, which have to be implemented by our fellow citizens who are not immune from bias. I appreciate your consideration today, and I'd like to invite to the podium some other members of the faith community, both who are involved in education and members of the clergy. I'll introduce them one by one, and then at the end I will take questions, and if you have questions for our panelists, they can speak with you after the press conference. I'd first like to invite the podium Reverend Stephen Lee. Pastor Stephen Lee is a pastor at the North Church in Mounds View, where he has been for 7 years. He leads the staff team, oversees the preaching, and works alongside the elders in vision and strategy. Pastor Stephen Lee.
Good afternoon. As a pastor committed to the well-being of our state, I oppose the Equal Rights Amendment. It's deeply problematic legislation for all Minnesotans, especially people of faith. And so I want to share 3 reasons why this legislation is not good for Minnesota. First, the ERA ignores the rights of over 80% of Minnesotans. 80% of the population in the United States identify as religious. Most Minnesotans have some religious faith that should be protected against discrimination. This amendment doesn't do that. It lacks any conscientious objections for faith communities, and churches and other organizations could be mandated to endorse practices or speech that would otherwise violate their faith. Second, the ERA exacerbates constitutional conflict. This amendment pits the constitutional guarantee of all Minnesotans to be able to worship according to the dictates of their own conscience against these newly defined so-called rights of pregnancy, gender identity, gender expression, and sexual orientation. And so this will create an internal incoherence in the Minnesota Constitution. This will harm faith-based organizations and be weaponized against those seeking to exercise their deeply held beliefs. And third, the Equal Rights Amendment discriminates in order to prevent discrimination. This amendment discriminates against faith communities. It advances moral progressivism, enabling the sexual revolution to bludgeon the religious beliefs of Minnesotans. This amendment tramples the ability of faith communities to live out their faith by demanding conformity to the so-called rights of the pro-abortion and pro-LGBTQ agenda. It will make it more difficult for faith communities to serve those struggling with unwanted pregnancies, gender dysphoria, and detransitioners. So as a pastor in this community who cares about all Minnesota, I urge our legislators to oppose this amendment that will not lead to a unified Minnesota. As a Christian pastor, I hope that all will come to know the love of Jesus, revealed in his death on the cross for sinners. Jesus receives all to come to him without discrimination to find hope, healing, and forgiveness in the cross. Thank you.
Thank you, Pastor Lee. The movement to protect religious freedom and protect Minnesotans from religious discrimination is supported by people of all faiths and backgrounds. And today we have with us Rabbi Avigdor Goldberger. He is an educator and community builder who has served for the last 9 years as the CEO of the Minneapolis Community Kollel. The Kollel strives to elevate and energize the Minneapolis Jewish community through immersion in Torah study and exemplifying its ideals, thereby enabling every Jew in Minneapolis to study and experience authentic Torah. Glad to welcome to the podium Rabbi Avigdor Goldberger.
Good afternoon. Thank you, Jason. It's so nice that all of you came out here today, and for all of those of you watching, thank you for watching and paying attention to this important issue. My name is Avigdor Goldberger. Not your fault, Jason. Everybody butchers my name. I'm not a legal expert, and I'm certainly not a politician. If you're talking about Talmudic law, maybe I have something to say about that. I'm a rabbi, if you couldn't tell. My organization trains rabbis and teachers who then serve their communities in Minnesota and around the country. We also serve as an educational institution, which helps Jews of all backgrounds connect or reconnect to their heritage. I'm a proud Minnesotan and a proud Jew. If I had to pick an adjective that describes how I feel as a Jew today, that adjective would be grateful. If I had to pick an adjective to describe how I feel as a Minnesotan today, that adjective would be concerned. As a Jew, I'm grateful to live and raise a family in a state that provided a haven for my wife's great-great-grandparents escaping anti-Semitic pogroms in Russia. As a Minnesotan, I'm concerned about ensuring that my great-grandchildren shouldn't need to seek a haven elsewhere. As a Jew, I'm grateful for the right to stand up and openly express my concerns today, something I don't take for granted. As a Minnesotan, I'm concerned that I must exercise that right today. As a Jew, I'm grateful that the legislature passed a law yesterday protecting religious liberty. As a Minnesotan, I'm concerned that this new Equal Rights Amendment undoes the work of that amendment, that law, and fails to properly protect the rights of those groups most likely to face discrimination. As a Jew, I'm grateful that democracy is an inclusive and ever-evolving process where mistakes and oversights can be corrected. As a Minnesotan, I'm concerned of the consequences should we fail to make those corrections. So, as a grateful and concerned Jewish Minnesotan, I call on the state legislatures to fix this amendment to ensure that religion is still able to be practiced freely while protecting the civil rights of all people. Let's do the right and obvious thing so we can all be a little more grateful and a little less concerned. Thank you very much.
Thank you, Rabbi Goldberger, for those very powerful words. I'd like to introduce next Dr. Greg Johnson. Dr. Johnson is Vice President for Strategy and Chief of Staff at the University of Northwestern St. Paul, where he leads strategic planning initiatives, coordinates executive communications, and oversees community and government relations. Dr. Greg Johnson.
Thank you, Jason. Good afternoon. As Jason noted, my name is Greg Johnson. I serve as the Vice President for Strategy at the University of Northwestern, a Christ-centered university and media ministry in suburban St. Paul. As an organization, Northwestern is deeply troubled by the multiple elements of what has been proposed in the state legislature with respect to the ERA. I know the feeling is mutual with several of our fellow faith-based institutions, including Crown College, who's represented here by my colleague, Dr. Jen Niska. As you've already heard from the others today, the Equal Rights Amendment should always include protections for religious organizations based on the beliefs and freedoms that are granted to us by our Creator. If we're truly talking about equal rights, we should be treating everyone equally and with respect, even those whom we disagree with. In this case, that means not discriminating against individuals and organizations on the basis of their religion, no matter who's in power in our state government. From the educational perspective, what has been proposed threatens our exercise of some of the foundational and doctrinal elements and beliefs of Christian private education, both in K-12 settings as well as that in the higher education arena. These are practices such as the inability to teach what we believe, such as being created at birth, mind you, not by our own choosing as male and female. Similar to the words that have been shared by testifiers in committee hearings related to the State Human Rights Act this spring, leaving religious protections out of the ERA threatens our hiring practices. Specifically, this means that the faith-based organizations and schools may be forced to hire transgender individuals or those who are not living according to church teachings. In late April, the presidents of Northwestern, Crown, and 5 other faith-based colleges and universities sent a letter to our state's legislative leaders asking that they restore the pluralism that was once protected by the Human Rights Act. This pluralism allows Minnesota institutions that hold diverse views, including its private institutions of higher education, to live well alongside each other and to serve the diverse needs of Minnesota residents. Yesterday in this very building, the Senate and the House passed amendments that did just that, extending the religious exemption to all protected classes. However, in a quick about-face by the legislature, the pluralism that's recognized in the religious exemption is in peril, along with many other freedoms and protections that would come as a result of the proposed Equal Rights Amendment language and what it doesn't include. The pluralism of these values has worked well for 30 years and can continue to guide a diverse community of educational institutions to live out their differences in an equitable and inclusive manner. Therefore, we once again ask that our elected officials allow such pluralism to continue by including religion in the ERA. Thank you.
Thank you, Dr. Johnson. I'd like to bring to the podium to talk about some of the legal ramifications of the exclusion of religion from the Equal Rights Amendment, Renee Carlson. Renee is General Counsel of True North Legal. True North Legal promotes and defends life, family, and religious freedom by engaging in education initiatives, public policy, and litigation in the courts. Renee Carlson.
Good afternoon, everybody. Thank you for being here today. Minnesotans of all faiths should be free to work and live out their faith in accordance with their religious beliefs. But the so-called Equal Rights Amendment, also called the ERA, undermines that right by deliberately omitting equal protection based on religion. This puts religious freedom at risk of being suppressed in the name of equality based on gender identity and a constitutional right to abortion. The proposed amendment instructs judges to apply the highest level of scrutiny to discrimination claims based on gender identity and a constitutional right to abortion, but not religion, thus elevating those rights over protections for religious individuals, institutions, and organizations. Although the Minnesota Constitution includes conscience protections, the so-called ERA gives judges a blank check to determine that protections for gender identity and abortion supersede protections for religious people and organizations. Even worse, the author of the so-called Equality Amendment has not been clear about its reach. Based on her testimony, it's not unreasonable to assume that a state actor will be interpreted quite broadly. This means religious organizations with a tax-exempt status or private institutions that participate in government programming could be subject to penalties under the law. Their offense? Living out their faith according to their religious beliefs here in the state of Minnesota. Living them out in the public square. Ironically, the proposed amendment forces religious organizations to acquiesce to the government's near-liturgical worship of gender ideology and abortion, or choose to violate the law. How will religious organizations or people of faith who, quote, discriminate, end quote, be treated? Will it cost them receipt of government funding, participation in programs, or loss of their tax-exempt status? Even worse, will religious organizations and institutions be subjected to a continuous revolving door of complaints by the Minnesota Department of Human Rights or grueling litigation? Will the punishment be there for them if they do not comply with these mandates? We've seen this before in other states across the country. We've seen this in Little Sisters of the Poor. We've seen this in cake baker Jack Phillips, where they are punished simply for living according to their religious beliefs in the public square. After the mere mention and introduction of this legislation last year, a nonprofit organization that serves victims of sexual abuse in Minnesota informed me that they withdrew from a state grant program at the risk of closing their doors because the state created a policy that would force them to house men who identify with women in order to receive state dollars. This amendment threatens the existence of ministries like homeless shelters and other faith-based domestic abuse shelters that serve women and make sex-based distinctions. This could even obliterate girls-only dorms at institutions, locker rooms, and sports teams. Is that the kind of Minnesota that we want to have? Is that what equal protection means in the state of Minnesota? Put simply, the so-called Equal Rights Amendment tells many, many Minnesotans, represented by a number of diverse faith communities, that providing services across the state are not important because of their religious beliefs. It also tells them that gender identity and abortion are important, but as religious people, they are not. Friends, reporters, people listening today, that is not equality.
Thank you, Renee. I want to highlight something before I open the floor for questions that a number of speakers have alluded to. Because of the protection of some classes and some considerations, particularly related to abortion and gender, and not including religion and not protecting people of faith who might have different views about abortion and gender than what is protected by the ERA, it actually has the perverse incentive of allowing and enabling a whole host of anti-religious discrimination, including Islamophobia and anti-Semitism, among other things. So by not protecting against any religious discrimination in the ERA, we are enabling all kinds of it without this exclusion. And that's a really, really important point, is that trying to suppress the voices and views of people of traditional faith ends up harming all Minnesotans, regardless of whether they have a religion or they have none. With that, like I said, I'm sure some of our speakers would be ready to take questions after the presentation, but I will take some from the press.
It seems like Stop ERA is kind of the priority here, right? Like, just, you oppose its passage. But I also heard some support for getting religion included as one of the protected classes there. Is that, so is stopping ERA kind of the first priority, and then if you can't stop it, do you want to try and get religion included in it?
Well, I think it's important to note that protecting people against discrimination is a compelling governmental interest. So what should we be doing? Yes, we should be protecting people from discrimination. There should be an equal rights amendment, but it should be inclusive. So we think if an equal rights amendment were to go onto the ballot in 2026, it should include religion. That would correct and mitigate a lot of the harms that our speakers today have identified. So yes, I think we have a lot of problems with it on a number of levels, but at minimum, if this is to go to the ballot, this should include religion and promote that healthy pluralism of views, not just among those who want to protect abortion rights and gender ideology, but also those who want to protect people of faith in a whole host of contexts as well.
And would you be on board with language like that was added to the Minnesota Human Rights Act earlier this week?
The remedy for fixing this is simply to add religion right in the list of protected classes, CC, race, ethnicity, national origin, and then just put religion right in there. That's a very simple fix. It's one word.
Even if it included pregnancy, qualifications, and gender identity, if religion is alongside, you'd be in support of that?
That would mitigate a lot of the harms proposed by the ERA, but at least putting on some equal footing between some of those considerations between the rights of religious people and their views and different viewpoints about abortion and gender ideology. We have to be clear that the proponents of this, primarily groups such as Gender Justice, who are the featured proponents and legal experts, they want religion not to be in there precisely because they want those rights to supersede any claims of religious freedom and religious protection. So the very good work that was done by our legislature yesterday could be undone if this goes to the ballot and gets put in law in our Constitution without protection for religion.
If that one word was inserted into this, would you be able to actively support the amendment?
No, we wouldn't support it, but it would go a long way toward at least providing somewhat more of a pluralistic dynamic and providing at least a minimum of protection for people of faith. We can agree to disagree. Again, I think the challenge for us is that, as Representative Herr has said, we have to pass the ERA to find out what's in it. So that's why we're concerned that perhaps if you put religion in it, that would help. But that might not be enough. What are courts going to do? And as Renee said, this is like a blank check to Minnesota courts to interpret this as they will. And will rights to abortion access, gender ideology, will that transcend rights of religion and religious discrimination? It's very concerning when Representative Herr said that receipt of public funds, having tax exempt status, make you a state actor subject to claims of discrimination. And so that's why we are deeply concerned about it. Would putting religion back in very much help? Yes, we think that's an important issue. But at the same time, there are a whole host of problems with the ERA.
But if gender identity and pregnancy protections weren't in this language, but religion was added, it sounds like those two pieces are the parts that are making you say that you wouldn't be against it, but adding religion would go a long way.
Speaking only for the Minnesota Catholic Conference, we are against this version of the ERA.
Okay.
That doesn't, as I made clear, protecting people against discrimination is a compelling governmental interest. We shouldn't allow discrimination against people for a whole host of reasons based on a whole host of identities. But what we're seeing in this ERA is the elevation of some identities and interests above the interests of others. The interests of all Minnesotans who, whether they have religion or none at all, should be protected from religious discrimination. Government should not be allowed to discriminate between religious and non-religious actors or between religious organizations amongst themselves.
Can you talk about what Democrats said in committee on Monday, which is that there are already protections in the Constitution? I'm just curious what
I'd be happy to. So Article 1, Section 16 provides rights of free exercise of religion. But that's only one remedy to fight the burden of religious exercise. So often if you file a lawsuit claiming an injury, you make a number of claims for relief. And those claims have different justifications and different legal bases, but they also have different remedies. So it's one thing to say that your religious exercise has been burdened, but you also might suffer discrimination in a different way. And so we want to create a legal remedy for all Minnesotans in our Constitution, so that when they suffer discrimination, they can go to the courts and say, hey, I've been discriminated against, or my organization has suffered discrimination, and we're entitled to legal remedies. And despite the fact that our case law gives heightened scrutiny to claims based on that Article 1, Section 16, that's simply case law. And what we're asking for is it's in the actual text of the Constitution, so it can't be manipulated by judges, that they're always giving the highest degree of scrutiny to those claims in which people are saying that they've been discriminated against based on religion. So what's in Article 1, Section 16 is necessary, but it's not sufficient, and not sufficient in this context where we're giving the highest level of protection to claims of pregnancy discrimination, gender identity, et cetera, which I think some people hope would supersede other interests. And remember, the fundamental premise of the ERA is that, well, we already have these protections in law, but someday a court might decide otherly, or someday otherwise, or someday the statutory protections might go away. Well, the same goes for what we're arguing too, is that, yeah, there might be other protections for religious exercise or against religious discrimination, such as in the Minnesota Human Rights Act, but what did we just have to do? Fight for a religious exemption to go back in. So what putting it in the Constitution does is ensure that those protections are going to be strong and they're going to be enduring.
Can I ask Renee Carlson a question? Because I think the Senate version said creed. You guys are saying religion. Is there a difference legally, do you think, between these?
Again, speaking only from Renee, I think would rather speak afterwards, but speaking from Minnesota Catholic Conference standpoint, religion is broader than creed. It speaks to a whole variety of practices. It has a whole line of jurisprudence in the case law. It matches up with other words in our law, in the case law. It matches up with what's in federal law as well. Creed is sort of a different term. It speaks to beliefs, but not just practices. So I think religion provides a firmer basis. We would certainly not be opposed to creed and religion, for sure, but we think religion puts us on better footing in terms of protecting our rights.
I remember, oh, sorry.
Is it defined in law anywhere? I mean, these terms defined somewhere?
There's far more case law related to what religion is. It's in the Minnesota Human Rights Act, among other things. It's in federal law, Title VII, this 1964 Civil Rights Act. What the U.S. Constitution protects, of course, is the free exercise of religion.
Because, kind of to piggyback off of that, Speaker Portman, when she was asked about this a few weeks ago, said, you know, part of the reason they took creed out is that it wasn't defined in state statute. Is that your understanding? And I saw Representative Nisby here, so I was going to ask him that question if he knew. But you're saying religion isn't maybe necessarily explicitly defined, but case law is precedent.
Religion has a far more has a stronger legal pedigree than creed. So I wouldn't disagree with the speaker that creed just doesn't have that historic pedigree in the case law. But I think at the end of the day, it's about principle. Creed encompasses beliefs, whereas religion encompasses beliefs and practices.
What's the downside to just letting the voters decide this in 2026?
Well, it depends on what you mean by downside letting the voters decide it. They should decide, and what we should put in front of them is an amendment that values all Minnesotans, and they should be given the option to understand clearly what they are voting for and what they're not voting for. And so beyond simply saying, people aren't, who's against equal rights, right? But what does that mean practically? And I think voters, and your job in the media is to help them understand what this means, what the implications of those things are. But if we're going to be inviting them to put things into law, we should be doing things that protect people from all kinds of discrimination. Why aren't there protections against age discrimination for the elderly? Why aren't there protections against socioeconomic status and inequities in economic well-being? There are a whole host of things that are missing for this. And I think, as was clear from the bill presentation on Monday in rules, there are certain things that we are trying to protect here, the proponents that is, and that's access to abortion and gender ideology. There's no disputing that. So what we think is that Minnesotans deserve something better. They deserve an equal rights amendment that protects all Minnesotans and all values, not just privileging the interests of a small minority over everyone else.
Do you think the ballot language is honest?
I think that one way of looking at it is it's clear as to what they want to protect in there and what is excluded. But I don't think people understand that pregnancy extends to abortion without restrictions and what that means. So I think there could be some clarity there. I'm not going to opine here, and that's not the purpose of our press conference today, to opine about what the clarity in the ERA looks like.
If this passes, what would have religion included? I mean, what does a campaign look like for groups that are opposed to this? And how do you message to voters that is not part of it?
Well, I think if you look at who was supporting the religious exemption in the Minnesota Human Rights Act, we had 15 diverse religious organizations come together. Christians of all varieties, Muslims, Jews. I had inquiries and people considering from outside those traditional faith communities. There's a lot of new Minnesotans in different faith communities who are considering this. And I think Minnesotans across that faith spectrum are going to be really troubled, and it's going to be one more reason for either people to not check that box in favor of the ERA or to vote no, because you know how constitutional amendments work. If you leave the box blank, that is equivalent to a no vote. Without religion, that's just one more reason for a whole lot of Minnesotans, even if they're not concerned about some of the abortion and gender language that some of the groups here are concerned about. It's another reason for a larger group of Minnesotans to say no to that. And they're already aware of threats to religious freedom and religious exercise in Minnesota, and we'll for sure certainly be talking about that as one potential reason to vote no. Thank you very much. I appreciate you being here.